Welcome to my presentation of how monism and dualism work together to implement legal compliance within international treaties. This will be within the scope of climate change and such agreements. Looking at the overview, there will be an introduction, explanation of legal principles, discussion of issues, recommendations, and a conclusion. Now, when looking at the legal systems that govern countries, there are different types. There are two main types, such can be international and national laws. International law comprises of legal relations between states and international institutions, such as the United Nations and the World Health Organization, as they are large legal personalities within the global scale. Now, international organizations operate within a threefold sense. One, they are given power by law. Two, they are governed by law. And three, they must abide by the rule of law. The main goal of international law is to govern nations towards peaceful international relations amongst countries. International law is governed mainly by international agreements between countries. These are judicial instruments which reflect the will of countries working towards a common goal, and such is defined in the 1969 Vienna Convention. Looking at the question at hand, the multilateral agreement signed towards a common goal of addressing climate change is an example of an international treaty. This reflects a real-life example of the 2015 Paris Agreement. This was an international treaty adopted by 196 parties in 2015. International treaties are thus governed by the Vienna Convention on the Law of Treaties. As per Article 2, 1a, it defines a treaty as an international agreement concluded by states written in a form and governed by international law, such as in the question the Multilateral Climate Change Agreement. Whereas on the other hand, national laws refer to a set of rules made by a nation which govern the conduct of individuals within the jurisdiction. National laws are created by legislative bodies enforced by national courts. Examples would refer to acts of parliament. Now that there is a better understanding of what national and international laws, it is crucial to understand their interrelationship. The main two doctrines which govern these are the doctrines of monism and dualism. Looking at this, according to the teachings of monism, this is most prevalent among civil law countries. Both international and national laws are contained within a unified system where international law takes priority. This means that in an event where there is conflict between national and international laws will indeed prevail. The international lawyer Hirsch Lauterpacht is a famous advocate of such school of thought. In the case of Burvat v. Burbit, it was held that the law of nations in its full extent was the law of England. This shows how monism operates. When looking at dualism, which is more consistently applied among common law nations, at the heart of the theory lies the idea that both national and international laws are two different entities. Unlike monism, where conflicts arises between the municipal and the international laws, national laws here will prevail. The case of Chung Chi Cheng shows how dualism operates, as it was held that international law has no validity except in so far its principles are accepted by our own domestic law. Famous political philosopher Hans Kelsen advocates for the doctrine of dualism. Now, looking at the explanation of legal principles, when it comes to monism, this theory is supported by the doctrine of incorporation. This suggests that when international law is set, it automatically becomes operated into municipal law. Thus, international law is also ipso facto part of the municipal law, and subsequently can be applied within national courts. Conversely, the doctrine of transformation corresponds with the theory of dualism. This states that in order for international law to take into effect into a country, there must be an enabling legislation to be passed by Parliament to give power to such international law. An example can be said to be the Human Rights Act, the HRA, in the United Kingdom. This gives rise to the European Convention of Human Rights. Usually, the executive organ is given such powers. An example is in Malaysia. Article 74 of the Federal Constitution, read along with the Federalist, is evident that the Malaysian Parliament has ability to enforce international treaties by the passing of legislation. This matter was confirmed in the case of Kelantan v. the Federation of Malaya and Tunku Abdul Rahman, where it was held that despite an international treaty of the Malaysia Agreement, that consented of individual states of the government should be obtained before agreements for Malaysia. There indeed was nothing in the constitution saying such. More so, there was no enabling legislation pertaining to the matter either. This is evidence that Malaysia follows dualism. When it comes to the doctrines of incorporation and transformation, usually they're applied in a mixed ratio. When it comes to international law, for example, there are two forms: treaties and customary international law. The United Nation, the United Kingdom, for the law of treaties, adopts the doctrine of transformation. And the following articles convey the relationship between national and international law. Article 27 of the Vienna Convention on the Law of Treaties, the VCLT, states that any nation who subscribes to the convention cannot plead municipal law as a valid reason in invalidating international law. This further shows that countries do not usually stick to a rigid regime, rather a mixed flow of the two doctrines. Furthermore, under Article 47 of the same convention, it mentions a state cannot invoke the provisions of internal law as justification for its failures to perform a treaty. The provision establishes a fundamental principle in international law that a state cannot use its domestic laws as an excuse for not fulfilling its obligations under an international treaty. Once a treaty is ratified, a state assumes legal responsibility that must be honored. Thus, in the question at hand, once a state ratifies the multinational agreement on climate change, they are bound by the duties set out in the agreement over their own municipal laws. This will depend upon if the country follows monism or dualism. How the nations will be bound this also determines how nations will be bound upon duties. A country like Australia follows dualism. Hence, there must be acts of parliament which are passed to give rise to the treaty. Such nations, after ratification, adopt different policies too, in order to abide by the rules in the agreement. Furthermore, if a nation sets out reservations in the agreement, it means that it will not abide to all the duties, more so only selected ones. The legislation may incorporate the entire agreement or only parts of it depending on the state. For example, Papua New Guinea has enacted a United Nations Paris Agreement Act of 2016 giving power to the 2015 Paris Agreement. More so, if nations to the climate agreement following monism, the laws will automatically translate into national laws, such as seen in the Netherlands, where Article 93 and 94 of the Constitution verifies that international treaties, once ratified, form part and parcel of domestic law, thus taking precedence over Dutch laws. When it comes to choosing monism and dualism, it is integral to look at their advantages and disadvantages. Now, when applying international treaties, one of the issues that may arise is the understanding of the law. Relating back to this point in the question, a fundamental disparity may be that in terms of legal compliance, there can arise ambiguity as in how to apply and interpret international law. This can lead to misunderstandings amongst judges and cause confusions. The case of United Kingdom, Smith v. Smith, this states this was a case in where the House of Lords ruled that whenever two interpretations arise, the one closest to international law shall prevail. Furthermore, in the international case of Somalia v. Kenya, it highlights how judges can interpret differently, judges can interpret treaties differently. The ICJ ruled that in this case, the object and purpose was necessary in resolving the dispute around the issue of maritime borders. Now, another challenge faced in regard to adopting international treaties is when there is a sense of urgency as per the topic of the agreement of nations abiding to dualism. Such issues can arise when delays come around. Dualism may face delays in implementing enabling legislation giving effect to the treaty. An example can be seen in Norway. The Law on Kalimal Climate Change Act of 2018 incorporates the Paris Agreement of 2015. However, the act arose in 2018. This was 2 years later after the Climate Change Agreement of 2015. This shows implementation delays exist, and this is a drawback of dualism. Another challenge faced by nations who subscribe to dualism include lack of political will to implement the treaty. Prior to the Paris Agreement of Climate Change, there existed the Kyoto Protocol. This was the predecessor of the Paris Climate Agreement. Canada was one of the signatories to the Kyoto Convention. However, due to lack of government support and little action was taken into actually implementing the agreement domestically. This is reflected in the case of Friends v Canada, in the case of Friends of the Earth v Canada. There were where here courts held that Canada had no role to play in enforcing the Kyoto Protocol. It was held that despite enabling legislation such as the Kyoto Protocol Implementation Act of 2007 was passed, it was decided that despite the act existed, it was held that it was only a private member's bill and thus lacked adequate government support. Another challenge faced when nations subscribe to dualism lies the ambiguity of implementation. This problem arises from the fact that there are many methods to implement treaties. For example, in the UK, a treaty may be attached to statutes giving it power. Parliament may pass an act granting government officials power to execute obligations under treaty, or Parliament may pass an act such as enabling legislation, which has been mentioned before. All of these can lead to legal incompliance due to ambiguity. Now let's talk solutions and recommendations. Now, a solution to the ambiguity of judicial interpretation in monism can be solved by looking at the case of Libyan Arab Jamiri Han versus Chad, where it was held that a treaty must be read in line with Article 31 of the VCLT. The underlying principle was that the underlying principle was the principle of pacta sunt servanda, which is Latin for a treaty must be kept. Thus, if judges have different opinions on the matter, they should all resort back to this principle. Now, another solution to the delays of political lethargy in implementing laws on climate change can be reflected in the case of Asghar Leghari v. Federation of Pakistan. This sets out precedents of how policy affects legal compliance, legal rights imposed, and failure of governments to act fast can be solved by courts directing governments to act with an urgency. The case facts here are such that a farmer who was affected by droughts due to global warming brought forward a case towards Pakistan on the grounds of incompliance towards climate change policies. As a remedy, the Pakistani courts ordered the creation of the Climate Change Commission who will implement the national climate change policy. Now, a solution to the issue on implementation can be seen in the Australian case of Project Blue Sky. This brought about the phenomenon called quasi-incorporation. So, what is quasi-incorporation? This simply refers to when statutory directive is given to policymakers and governmental departments in order to take consideration international treaties. Now, looking at the lack of political willpower, the case of the Live Water campaign in the Netherlands can be a great way to come across. So, in the Netherlands, the campaign sought to increase public awareness of the river coastal floods brought about by climate change. The goal of the project was to educate the public and decision makers about the dangers of floods and the value of adaptation strategies, to include communities and to promote local action. The campaign used a variety of communication techniques such as public gatherings, printed materials, and social media outreach. Consequently, it increased political support for floods. So now moving on to the final part of the presentation, which is the conclusion. There are many ways in which international treaties can be applied to the nation. This depends on whether a country subscribes to either monism or dualism. However, regardless of the system, each have their positives and negatives. In order to adhere to compliance of urgent treaties such as climate change treaties, it is very important for nations to look at political strategies and legal solutions, such as adhering to stick to a single interpretation of Article 31 of the VCLT, creation of climate commission get judicial orders to administrative branches such as quasi-incorporation and promotion of local campaigns pressuring governments to act within international treaties. Thank you.